Welcome to Victim to Victory, the authority in personal injury. Today we have the pleasure of having the managing attorney at Bader Law, Jason Green. Welcome to the show.
Thank you for having me on, Lawrence.
It's my pleasure. Now we've had a similar journey, going from litigation into being the managing partner at a big law firm. You down in Atlanta, us up in New Jersey. So tell me a little bit about your litigation experience as one of the top prosecutors in Georgia.
Yeah, so I think that was honestly one of the most exciting times in my career. And I loved the fight. I loved feeling like I was protecting the community. Of course, it was too late to protect the individuals, the victims in those cases, but seeking justice for them and vindicating them was incredibly rewarding. And I learned to do it where the stakes were the highest. Ultimately, I dealt with many rape and sexual assault cases, and most of my trials were actually homicides or death penalty cases. And so, in those kind of environments, people know, the juries know that you are asking and that the person will probably be sentenced to decades, if not life. And so they are very cautious about the verdict that they render. They do not do it without the evidence. And so I learned in that environment that you have to not just have the facts, but a compelling story. You have to not just move their logic and intellect, but also their emotions. And now that I've switched over to the civil side, I feel like it dovetails perfectly with the plaintiff's injury role, plaintiff personal injury role, because once again, I get to look out for the little man. And I understand that the jury, or if we're trying to get the case resolved early, the claims team isn't just looking at the medical chart, in that you have to weave it together with all the aspects of their life and their personal circumstances and develop a cohesive, compelling story that hopefully will move the claims team, but if not, the jury.
Well, it's incredible the amount of trial experience you garnered in the criminal area as a prosecutor prosecuting big murder trials. I know you once had a jury come back in 5 minutes with a guilty verdict, so that's pretty incredible. They didn't have to think about how much money to put on that one, so that usually takes a little time when they start arguing about how much money to award a plaintiff. So those verdicts take a little bit longer. But you've explained some of the things you've learned, and what I love about you is you have the exact same philosophy that we have up here at GGL, and it's you prepare every case for trial. And I think that's our niche in the industry up here in New Jersey, because a lot of law firms, as you know, do not prepare every case for trial. So take us through that process and why you prepare every case for trial and how that gives you an advantage over a lot of the firms that just want to settle cases.
So actually, that's a carryover from my criminal days also. So again, when those high stakes cases, it is extremely unlikely because of the stakes that the person is going to take a plea. I would say the vast minority of those cases are wound up in a guilty plea. So I just learned, I didn't really know any other approach, that we've got to start building this file for trial from day one. And something funny, as you know, Lawrence, happens along the way. The more you develop that evidence and sharpen your talons, the more the other side starts to see the light and think about how bad this could be for us. And so in the criminal world, I would start getting those calls. Hey, can we do a reduced sentence? Or, my guy will cooperate on this guy, whatever it might be. And so when I came over to the civil side, it just seemed a natural extension of my experience. Like, let's build it from day one. Let's assume that we're going to be in front of the jury. Of course, as you also know, evidence tends to erode and get weaker over time. So that's another reason strategically and technically to go ahead and start building up. Your memories are fresher. Your evidence is going to be more readily available. And so let's start with that. And then sure enough, the pattern held. Adjusters, opposing counsel would see, wow, he came into that deposition and he's got his experts or whatever it might be. And he's asking incisive, powerful questions and getting us hung up. And then, as you know, the offers start coming in, you push them back, and it's almost like they're running you down to try and settle the case then. And so the throughout my legal career, that has really been the only way that I have known to prepare a case. It's just to assume that it is going to go and be heard by 12 of my fellow citizens from day one. And if they offer me an off-ramp and it's reasonable and it's fair, whether it's criminal or civil, we'll take it.
Now, let's talk about a little bit about the trial itself. Now, you've prepared your case for trial. Now, what advantage does that give you over another firm who may not prepare every case for trial? How's that work as an advantage to you and Bader Law?
I think the number one thing that comes to mind is you learn things that are not necessarily going to show up in the usual and customary documents, right? So the other side certainly isn't going to help you build your case. So they're not asking questions in their interrogatories or RPDs that are going to develop facts for you. It's not going to show up in a medical chart. If you have witnesses to either a crash or premises injury or something else, like they have a snapshot of what happened that they can attest to. Even an expert is retained. But what you and I know is that when you start talking to that client, that injured person, their families, their friends, their neighbors, their coworkers, you get those additional details and context that can take a good average case and make it great, because now I have that human story, and now I can weave this narrative. I can tell this tale to a jury, and I can now incorporate those rote objective facts that I've got and weave them into this narrative. And so what comes out on the other end is this literally cohesive thing where, yeah, I've got all the technical stuff, I've got my experts, and I've got my medical, but I can weave it together with that human element and talk about how this impacted that. And at the end, again, whether it's to a claims team, opposing counsel, or ultimately a jury, I'm confident in what we put forward, that I'm telling the best story for that client.
Well, what I love about what you're saying is I always preach to our team about jurors pay people they like, so you have to humanize them and tell their story. They're not going to award you a big verdict on medical bills. It's going to be on the story and the effect it's had on the client. So I always tell our team, always bring a before and after witness. And you describe that as friends, family members. So you're going out and getting those depositions. Explain, and we call them a before and after witness because they can testify to what the person was like before the collision or the fall and after. So tell our audience, why is it so important to use a before and after witness?
Yeah, we refer to it the exact same way, as a before and after witness. And I jokingly, I don't say this to clients, but I say this to the lawyers on our team, like nobody is going to, meaning a jury, nobody is going to pay you because you were uncomfortable watching Netflix. That's just a kind of flip way to get the point across that, you don't have to be doing bungee jumping, but they do want to hear something about, missed birthdays. I had one client who missed her son's wedding because she fell at the airport and was seriously injured, had to have emergency surgery. but how she missed this life-defining moment. You want to look for things like that, and that's the kind of thing that you really only get by delving into. I mean, that one was a little easier because it was top of mind, but as you know, Lawrence, because you preach it to your team, once you start interviewing them and really pressing, and what we also know, right, as experienced practitioners is that many times this has become the client's new norm. So they don't even necessarily realize all of the adjustments they've had to make along the way. They've just, because most of them are just hardworking, honest people who something negative befell. They're just trying to carry on their life. So they've already made the adjustments. And by the time you get to the litigation stage, they're not even really thinking about what was my baseline before. My point being, you as the legal team have to be very intentional and conscientious about probing for those things, asking those questions, listening for little things that raise a flag for you to follow up on and to delve deeper into. And so it's not something that you would just automatically get to. And I think that's one of the mistakes that a lot of clients make when they're, on the consumer end, but also lawyers, is they just think that these things fall out of the sky. But many times you have to be very purposeful and intentional in looking for them.
And the amazing thing about a before and after witness is they're not subject to cross-examination. There's really, the best lawyers I've seen on the defense, they ask maybe two questions of a before and after witness. Be like, well, you love your friend and you'd like to see your friend succeed, correct? That's about all they can do, because these people are not talking about themselves. They're talking about somebody they know and what they've seen that person go through. So I think that's a great point, and I'm glad you're here to talk about that. That really works with the jury. It really resonates home what this person lost. Now, you go from litigator, like I did, trying a case almost every week, always on the trial call, trial after trial. And then all of a sudden for me, it was COVID hit. And I went and took a look under the hood of the firm and said, okay, we have to make some changes. And then next thing I know, I was the managing partner. So how did you go? Talk about that transition, because I tell everybody, I'd much rather go back and get my caseload and just try cases. It's a lot easier than running a huge firm and trying to deal with all the personalities. So tell us about your journey and how you feel about that.
Yeah, so it's interesting. I kind of got into managing attorney role the same way I kind of got into the practice of law. I mean, not the practice of law, but litigation trial work, which is, it really found me. So I was interviewing at a prior firm for a litigation role, was not interested in managing attorneys. And I get asked maybe halfway through the interview, hey, would you consider managing attorneys? And really hadn't thought much about it. Of course, I've had managing attorneys in the past and started to reflect. I said, give me some time. Long story short, I decided to try it. And there were things that I liked about it. And the number one thing is I love collaborating. I was about to say training, but it's yes, there are formal training aspects to it, but really what it is helping you build a case, partnering, mentoring these attorneys, and telling them ways to view particular facts or circumstances or witnesses. And I really got a lot of pleasure out of that. And so when I was approached by Seth Bader about coming on board, and he was telling me about what he wanted me to do, which was make Bader Law a true litigation firm. I mean, of course, they've always had litigation, but really where that is the emphasis more than anything necessarily pre-litigation. I like that mission. I like the challenge, like changing the trajectory of a firm. And so I have 3 attorneys who really is 4, because we just added another one who I've worked with in the past, but we also have some attorneys that have carried over. And I love the team we put together. And I think now, correction, I know many of them are excited about the litigation first mindset that I have brought to the firm. and they have become equally, well, I guess, disciples of it, if you will allow the term.
Have you had any pushback about preparing every case for trial, and how have you scaled that throughout the firm to get everybody to buy into that philosophy?
First of all, and I think this was very helpful because it was Seth Bader's pitch to me that this is the kind of firm and the philosophy and outlook that I wanted to have. And so he was, as you know, there are costs associated with it, experts, demonstratives, all of these things. And so he's been incredibly supportive in making the investment to do those things on the front end. And so I'm glad that's something I didn't have to overcome. As for the attorneys, I think the number one thing, and this will probably resonate with you, is that there was a fear factor in some of them, particularly the ones I had not worked with before.
Can you explain to me, where is the fear? You're dealing with, in civil, we usually have 6 people making a decision, 8 people in the jury box that know very little about the law or medicine for the most part. I don't understand the fear when you know the case perfectly, you know the law, you know the medicine, and I don't understand the fear. Tell me about some of the feedback you got. What were they afraid of? Is it a fear of losing, a fear of embarrassing themselves? What's that fear?
You called it all off. I could just end by saying all of that, but no, to expound on it. I mean, for starters, as we know, everybody who's a lawyer, and then even those who call themselves litigators, there's still a healthy fear of public speaking in that segment of the population. According to studies, it's, if not still the top, one of the top phobias or fears of the general public. And what I'm trying to say for your viewers is lawyers aren't immune to it. So many of them who even claim to be litigators or trial lawyers, they're afraid of it. They are also afraid of losing. And I'm the kind of person, and I've heard Andre Agassi and other athletes refer to this like, I get more obsessed with my losses than the victories. They tell me much more, and they motivate me much more, and show me where I need to shore up a particular skill set or where I need to focus more. So my point is, I tell them, don't be afraid of your losses, learn from them. I am never, either as a human or as the managing attorney, going to look down on you for a loss, because we know, Lawrence, is if you are talking about a lawyer who claims that they've never lost a case, or they say, like, I've only lost 1 or 2, then you haven't tried many cases. So I think that's a rite of passage. I think it's nothing to be. Now, if you tell me I wasn't prepared or I didn't go hard in the paint for that client, now that is something to be ashamed of. But just that this particular time you couldn't get the result that you were looking for, there's no shame in that. And I'll end kind of my thoughts on, and I know this is not unique to me, but I have in my office the quote from Teddy Roosevelt, "The Man in the Arena," and I'm sure many of your listeners are familiar with that. But that encapsulates my philosophy perfectly.
That's a great philosophy. You have to respect the man that gets in the arena. And it's funny you say it that way, because I tell our team, I want people that are going to get in the ring and fight. So I use the same philosophies. It doesn't matter if you win or lose. You have to get in the ring so you can put the fear into the insurance company that you're going to try the next one and you're good at it and you're going to try it again and again. We had a gentleman here that tried, I think, 5 or 6 cases and lost. And then he had a great case. They overpaid him tremendously because they knew he's going to get in there and do a good job. And he's not afraid to try the case. Even though he had lost several others that were cases that weren't great, then he was cutting his teeth on. Once he got his hands on a really good one, they wanted no part of him because he showed that he was willing to get in the ring. So now, let's talk about that a little bit. You were on the defense side for a little while, right?
I was.
All right. So now talk about that. Talk about that philosophy when you're dealing with an attorney that's willing to get into the ring against you, and you know this guy's not going to back down. How does that affect the insurance company, the insurance adjusters?
Yeah. So I will tell you this, and I am not trying to, you know, engage in any puffery or being braggadocious here, but because I had a lot of trial experience, when I had a worthy adversary on the other side, somebody that I knew was either very experienced or I had heard of them either by reputation or I dealt with them in the past, I wasn't really worried about that because I had complete confidence in my own skill set. But what I can attest to is that many of my coworkers on the defense side were absolutely petrified to know just what you were talking about, that this person, number one, will go to trial. Because guess what? They have even a larger fear. What we know is insurance companies hate uncertainty. They want to be able to calculate everything, and trial is a risk for them. And so just one, the fact that you are willing to go to trial scares the bejesus out of them because it represents uncertainty. But then if they know that you're skilled, you're tenacious, you're relatable, personable, you tell a good story to the jury, they are petrified of it. And so I do think that's where the difference in lawyers kind of kicks in, because to put in a better product on the field, now you're striking even more of fear in the other side. And as you know, usually they don't want to let the best players on the field. They will usually try and come up with a settlement that they think will you and your client conclude the case.
I actually had a lawyer come up to me and said on a particular case that I did not think I could win this case. It was not, the facts were not good on liability and they were not good on damages because priors and subsequent injuries to the same areas. And he said to me candidly, he said, we ran it through the computer, some use Colossus or some version of that. And he said, we came up that the average attorney had a 5% chance of winning the case, but you have a 37.5% chance of winning the case. So we're going to offer you this. I couldn't get out of that courtroom fast enough because I was like, F. Lee Bailey, Johnny Cochran, and the Dream Team could come back and wouldn't win this case. So I couldn't get out of there fast enough, but it's the reputation you build up over time.
Yeah, for sure, for sure. And the same things that you and I were discussing a few minutes ago about how you have to be intentional in realizing and presenting the client's human story, they are usually oblivious to that because of the same dynamics we discussed. They haven't asked really, they ask that kind of catch-all, like, well, what do you want me to know? But they're not really looking for those details. And so they're not valuing the case right. To your point about the before and after witnesses, they don't usually have an effective cross for it. They might have an expert who will push back on your expert's findings or something, but they rarely have a comeback for those human dynamics. And usually, if you have an honest client, which I like to think I typically do, even if they have surveillance footage, it's usually easily put in context. There's usually something that your client can tell the jury to explain it and clear it all up. So they very rarely have an effective pushback to that.
The one thing you must enjoy being a civil litigator is you get to open first and close last. So how do you see that as an advantage over the defense bar in civil litigation by being able to speak first and last?
I love it. 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 First of all, and I think I've evolved. Matter of fact, I know I have evolved. So when I started out, even when I was having a lot of success on the criminal side, I really felt like closing, like, oh my gosh, like that was my reward for going to trial. I love, having the last word. And I still think it's highly important to jury's determinations. But what I have evolved to is that a powerful opening, it sets the tone, it puts the defense on their heels, you know how you, because you're presenting the case. They're reacting to your case, but you are presenting your case.
Right.
So you can weave the story, you can order the witnesses, the evidence, the presentation of everything. You are the conductor. You are literally putting forward the program director, whatever you want to call it. You are setting it, and in an effective opening, when I feel like I'm just hitting on all cylinders, I know I sit down and I'm thinking there's no way back for them. Like this is all I have to do now is execute on the plan. Like that jury looked like bobbleheads. They were just there, and they're glaring over at the defense table. And so I've seen my philosophy shift from closing to opening is the one where, to use the expression, I have to stick the landing.
Right. That's very interesting. I'd love to teach a trial class with you. I think our philosophies are so similar. We'd be a good team together, teaching younger, less experienced attorneys how to try cases and what's important in a case. So let's talk a little bit about. I know you're a member of the American Board of Trial Advocates. Your wife is a law enforcement officer. So tell me, how do these things interplay with you as now a civil trial lawyer?
Interesting is you were right to name my wife. She is my test person for everything, criminal and now civil. But I've also kind of do what I call the barbershop or beauty shop test, where I will workshop all of my themes with people. Either I no longer have hair, but when my kids were in the house and I took them to the barbershop, to the people there, now that I'm not really doing that, if it's at a cookout or, a Sunday dinner with, family, just whatever, I always am kind of workshopping themes and stories and seeing what resonates. Because what's vital to me is hearing not just my own thoughts or my lawyer's thoughts, because we're kind of simpatico, but I want to know, because what we know is the juries are comprised of regular folks who, work at the Applebee's and deliver your mail. So I want to know, what does the average Joe think about this? When I have a complex concept, whether that's engineering or a medical point, like how can I distill it down? And as Denzel Washington would say in Philadelphia, make it for a 5-year-old. Like, how can I, effectively do this? And so I'm constantly, and fortunately, my circle of friends and family are very receptive to that. They've kind of come to expect it now, for me to run those things by them. But I find it, to answer your question in short, to be essential.
Right. Now, you and I could talk about this for hours. I would love that. But we're coming to a conclusion of the episode. So if you could give some advice to younger, less experienced lawyers trying to get their footing and to become a trial lawyer, what's some of the advice, the best advice you could give them?
So really, 3 things pop to mind immediately. One we kind of touched upon, which is lose the fear. Whoever whether it's a local lawyer or Johnny Cochran, like they all started, they had first trials, second trials, so just lose the fear. Don't worry about the results. And I mean that in the literal sense. Don't worry about them. Be concerned, work hard, but don't let the fear control you. Number 2 is I really do try and think of everything, contingencies, backup. And, preparation gets you through the process, is what I tell my lawyers. The more you think of the different scenarios, well, what if the judge doesn't go with me on letting this in? Then what am I going to do? I know they've made this motion in limine. Let me not assume that my point is going to win. If this is, just whatever it might be, maybe their expert will captivate a jury more on this particular point. How am I going to shift the focus then? Just whatever it is, try and think through all of it, because that preparation will help ease those nerves, but also make for a more seamless and important viewpoint for the jury to grasp onto. And then the third and final thing is be your unique, authentic self. Everybody is not a powerful orator. Everybody's going to have different life stories, but really, I do think whether it's, again, my former criminal days or now with civil, juries are powerful truth machines, and they can tell when somebody's being inauthentic with them. So yeah, it's funny because, one of my mentors that I have learned a lot from was Keith Mitnick. And he would tell these stories about the barbecue eating contest. And I remember one lawyer, thought that was so good, and he tried to do, and he looked so polished. He's so urbane and sophisticated, and it's just not resonating. And that's what I told him is that's not your story. You don't look like you've ever had barbecue before. It doesn't ring true. Like, find your own story, tell it in your own voice, be true to yourself. So it's fine to use things as reference points. It's nice to, the best lawyers, I believe, liberally, kind of get from here and there and what they've seen. I've taken things from opponents like, oh, I like how they use that. I'm gonna incorporate that, but put them in your own voice, make them resonate with your own story and your client scene. Don't just copy wholesale from other people you admire.
Right. Jason, it was a pleasure. So if somebody wants to hire you for a personal injury matter, how do they find Jason Green at Bader Law?
That's it. Jason Green at baderlaw.com. That's I'm like many lawyers, I stay glued to my email, much to my wife's chagrin. So except for usually about 5 to 6 hours every night where I'm asleep, I'll typically get an email, or of course you can find us on the internet at baderlaw.com.
Well, hopefully, Jason, I'll see you at our next mastermind that the GGL firm in Bader Law is at, and we can sit down and talk about trial strategy a little bit more. It's been my pleasure having you on the show.
Likewise, I've truly enjoyed it.